Okay, welcome back. Our last session of the day, public bid law for the purchase of materials and supplies. It's a panel discussion, and joining us today, we have Ms. Jenifer Schaye as our General Counsel for the Louisiana Legislative Auditor's Office. In her capacity as General Counsel to the Legislative Auditor, Jenifer advises on public law issues and laws related to fiscal matters, ethics issues, and all public laws which impact political subdivisions and the audits of political subdivisions on the local and state level. Joining Jenifer is Angela Heath. You heard her earlier. She is our senior attorney with the Legislative Auditor's Office, and in her capacity as senior attorney, she researches and writes opinions on numerous and various questions facing the Auditor's Office, state and local officials, and public entities. Also joining us today for the first time is Patrick Virgadamo, our other senior attorney. In his capacity as attorney, he also researches and writes opinions on numerous and various questions facing the Auditor's Office. He assists in responding to questions submitted by state and local officials and public entities. All of their bios are in completion on the website, so if you have any questions about that. But in the meantime, please welcome our attorneys.
Thank you very much. Welcome our attorneys. Does that sound? Nobody welcomes their attorneys, you know? Nobody does that, Liz. Most people say, oh my God, it's tax time, I gotta go see CPA, I gotta go see the lawyer, the enrolled agent. So we're gonna try to lighten that up a little bit for you today. But we have, say appropriate that we follow the fiscal administrator. Because the fiscal administrator gets there, as David was saying, because people haven't reconciled their bank accounts, they haven't spent money properly. So we've done all kinds of ways to get you the information on public bid. So we thought about doing this way because we could approach the topics in a slightly different way, and I hope it helps you. We, as Angela said in her presentation, as we always say, if there's any questions you want to stop us and ask us, then, you know, do that right when you think of it. And that goes for all of you here at Pennington or people that are listening to us throughout the state. I feel like every time I come to CLGE, I feel like I'm coming so that I can meet some friends and people that have called us and talked to us. And we appreciate your calls. In case you were part of a group, I want to say this at the outset, in case you were part of a group who might have sent us a question on the internet in February, we have a policy that we always answer those within 24 hours if we can, or 2 business days. But somehow our server that accepted those questions accidentally got turned off. I'm serious. And, you know, that caused us to not get those questions until last night. And this morning, Angela's answered some, Patrick's answered some, I've answered some, and we're going to continue to work on them. So if you know somebody who says, oh, wow, you heard Jenifer and Patrick and Angela, they never answer any questions. That's somebody that was on laying out on our February server, on our server in February. We think we've corrected the problem, but I want to say that if you ever ask us questions on that and we're not answering, then know something did happen, and feel free to call us at our number. You know, I've given it 1,000 times, but let me say it again, 225-339-3871, 225-339-3871. So you can know that we can answer you in a more expedited fashion. What we have divided up the public bid this time in a different way, and that is that I want to give you the foundation of the public bid law, and then Angela's going to give you kind of the basics of the public bid law, and then Patrick is going to go into several of the major exceptions to the public bid law, that is when you don't have to follow it. So those are the sections you can think about. So what's the foundation of the public bid law? That is that it is based in Article 7, Section 14 of the Louisiana Constitution. And that's just basically saying you can't loan the people's money, you can't encumber the people's money, mostly you can't donate, and you can't gift. And so when you know that that's the basis, that's the foundation of it. Now, people will say, oh, that sounds so ungenerous. Yeah, don't we follow the Napoleonic Code where we believe in community and where we believe in open meetings and public records? We do. But because we believe in that, then we're not going to loan it just to you or gift just you. We want it to be that the public money is used for the public good, and that is that it is we are going to be talking about arm's length transactions when you're purchasing materials and supplies. Now, it's also arm's length transactions when you're doing public works and building buildings, but we're not going to talk about that so much today. We're going to talk about materials and supplies. Now, when we do, I told Liz we weren't going to do any slides for you because it's kind of death by PowerPoint sometimes. And so at this point, we'll say, just let's talk. And it's kind of interesting to talk to 200 people and about 900 on the web, but we'll try. So what are we talking about as a foundation of public bid? What's a word I've said so many times in just these past couple of minutes? Public. It's public. It's public money, it's public property, it's public time, and you and I, we're public employees. So that is what we're dealing with. We're not dealing with, in public bid, we're not dealing with my money or your payroll, your money that you get. We're not dealing with that. What we're dealing with is the public money of the guy who paid his taxes, the public money of the woman who's working in the store or the restaurant that we just went to at lunch. Public time we're also dealing with because that's commodity, that's important. And we are public employees. And, you know, I talked to a gentleman in our conversations this morning. I talked to a gentleman who was asking me what he had to do now that his quasi-public entity was receiving public money. He knew that was different. And so we sent him the statutes that tell him it's different. If you got money from United Way, he said, that's different than you. I said, that's different than us. So from $1, when you get public money in your municipality, your city, your village, your entity, it is public. And that's what we're going to be talking about now. What kind of transactions do we have with that public money for the purchase of buildings and supplies? Now, another part of the foundation, and the final part for me in this, is that public bid, and you probably heard me say this many times, because I say it to myself many times, learning it, is a prohibitory law. That means that what it says is what we do. It's not an illustrative law. It's not where I give examples of what you can do. You may, you may, you may. Public bid law is full of shalls. You shall do this, you shall do that. So we're talking now, we'll go to Angela, about what shall you do when you're following the public bid law. Thanks, Angela.
Okay, so I'm going to talk with you, like Jenifer said, about the basics of the purchase of materials and supplies. In the public bid law in Louisiana, there's two types of purchases, materials and supplies, and there's public works. Although we're not going to talk about public works, I do want to point out that the threshold for public works has been $250,000 for a long time, but February 1st of this year, it was raised to $260,000. So the threshold where you have a public work where you have to go out to bid is now $260,000 effective February 1st, 2026. So any projects from that date forward. It does not include, can everybody hear me? I'm always weird when I have this microphone, okay. It does not include services. Services are not a part of the public bid law. Services now, because it is public money and there is Article 7, Section 14 is still applicable, we always think you should, for services, do an RFQ or an RFP to select them, but you do not have to follow, you don't follow the public bid law for services, like professional services or even like, you know, personal services, the guy who cuts the grass type of jobs. Okay, materials and supplies are not actually defined in the public bid law, but they are understood to mean movable items, everything that's not attached to the ground or a building, right? Paper clips, pens, equipment like a tractor, vehicles, and those kind of things. If it's in the public bid law, less than $30,000 is the prudent person standard. You don't have to take any quotes or any step or any documentation. However, we think that, and we will recommend in that form that's in the materials that we gave you, and we have this on our website that you can look out. You'll see that we still say you should call around and get some quotes to see what the best price it is. You don't want to be buying $500 hammers, right? It's under $30,000, so I can just go out and buy this $500 gold hammer. No, that's not really a good use of the public funds. The next threshold is the $30,000 to $60,000 limit. In that one, you are required to get 3 documented quotes. And documented means, honestly, you can document it in your file. You can go to the website where they've got the price list and print that out. You know, it could be electronic, telephone, fax, email, something that you're going to get from that vendor to get the quotes. Oftentimes, when people, and then let me give you the next threshold. If it's $60,000 or more, that's when the full bid process comes in. You have to advertise the 2 times. The advertisement has to be at least 15 days before the opening of the bids. And then you go through that entire process, following the public bid law exactly as it's set out. We get questions when you get that $30,000 to $60,000 limit. So I've got my 3 documented quotes. Do I have to take the least expensive one? Now, if it's public bid, if the bidder goes to the lowest responsible bidder, there's no leeway there. But when you get the quotes, you don't actually have to take the lowest one, but you need to document a good, legitimate business reason why you went with the one that was slightly more expensive. An example I have is during COVID, when there was a supply chain issues and things like this, I got a call. I can't even remember what kind of agency it was, but it was over the 30,000, but less than 60. He said, I've got these quotes, and 2 came in within $500 of each other, but the one that's $500 more expensive can get it to me by the end of the week, and the one that's $500 less, he's talking like 3 weeks to the end of the month. Can I take the one that's $500 more? I said to him, I think that seems like a real legitimate business reason to take the one that's $500. Just make sure you document it in your file. Documenting in your file can be a memo that you wrote that attests why you're making that decision. It's something that can be there so that other people can come back and look and see why you, or the auditor for sure, can come in and look and see why you selected that one, right? There's also another threshold, and that's for vehicles that are going to be used for law enforcement. Also now it's been expanded to fire and the apparatus. That threshold limit is $70,000. So you can buy a vehicle to be converted into a police or used for fire up to $70,000 before you have to go out for bid. And the law is now clear that it is per vehicle. So if you know, because before we would tell people at the other threshold, well, I got the car, it's under the threshold, and I want to buy 3 of them. Like, no, because if you add up all 3, it's going to be over the threshold. that now it says you can go out and you find that vehicle you're gonna use for police, $69,999, you can buy 10 of them if that's what you want, and you're still within the law. But it also includes fire and apparatus in there. So I think that is also the conversion. A question we got one time was, well, I'm buying the car to convert it, and it's under 70, but the apparatus to convert it into the police car is gonna push it, that's under 70. Do I count that together as one purchase? And honestly, I said, we have to ask the Attorney General, because it's not clear from the way the statute is written, because this city wanted to count it as two separate purchases, right? The apparatus separately and the vehicle separately. That's an area that needs some more clarification by the Attorney General. So, now, when you're going to go out to bid, you also have to consider how you're going to go out to bid. You can do electronic, all electronic, you can do all in person, you can do a mix of them. You have to decide that, and you have to have, in my opinion, a documentation of every step of the process, like a manual. It doesn't have to be overly complicated, but you need to designate for your entity who does what in this process. Who writes the check? Who is going to receive the purchase? That should be someone different than the person ordering the, placing the orders. And who's going to monitor it to make sure you are actually getting what you're paying for. That's a good thing to have in case, personnel changes so people can know how it's being done. It's also very good for your auditors to be able to see what your processes are, and also if there's any federal money coming in, the federal government is gonna want to see that you have written manuals of documenting your processes. So you can justify what you did, and if there's any personnel changes, keep that consistency. Now, before you go out for bid on anything, you have to have a reasonable cost estimate. A big problem or a big issue is often in entities you have things called recurring purchases. You're buying the same types of thing, but you're doing it really monthly. You're not buying all your office supplies in January, right? And so you can say, well, I only and you should count like things together, like all office supplies, papers, pens, paper clips, things like that. You estimate what you're gonna spend for the whole year based on your previous 2 years, what you spent. If that limit hits the 60,000, then you need to go out to bid. You don't just go buy your paper as you need it every month. You estimate what you're gonna spend for the year, and if it's over 60,000 or over, you go out to bid, and what you do is you get a requirements contract where the bidders are gonna be giving you the prices per unit of the different things. You're gonna award the lowest responsible bidder, and then as you need it every month, you're gonna issue a PO to that vendor, the winning bidder, and get what you need on a monthly basis. And sometimes maybe you don't spend the 60,000 a year, but that's okay because you based it on your reasonable estimate. Also, you need to make sure you plan ahead to count your days, that you got your advertisements done correctly. And when it comes to the selection of the lowest responsible bidder, what's responsible is not actually defined in the materials and supply side of the public bid law, but you can, if you believe this person is not responsible, somebody is the apparent low bidder, and you think they're not responsible, you can, at that point, because maybe this is a vendor has gone through LLC, goes bankrupt, doesn't deliver, forms another LLC, starts doing it again, doesn't deliver properly, goes back, he's just the same kind of bad actor. You can disqualify that person and not award it to him, but if you're gonna do that, you have to give them a due process hearing. That consists of written notification that you're gonna disqualify him as not responsible, so he's not gonna be the apparent low bidder, and he's not gonna get the low bidder, and within 5 days of that written notification, you have an informal administrative hearing. You let him present his case that, no, I'm a reformed man, you can trust me now, you shouldn't disqualify me. And then when you make the decision, you have to deliver it to him within 5 days of that hearing, that the decision of, yes, we're going to disqualify you, or no, we're not. And if you did disqualify him, you've got to hold off 5 days before you award to the now apparent low bidder the contract, because that 5 days, he is allowed to go to court and sue you to get an injunction to stop you from awarding that. So it is possible, and you can do it even before the bid happens to disqualify somebody, but a lot of people like to take the easy way out. Hope he's not the low bidder, and then you don't have to go through the process. So, I mean, that's kind of a judgment call on your part if you're going to want to do that, okay? Yes, you have a question, Judy?
Yes, can public entities other than fire or police purchase 3 vehicles that each cost $40,000 without a formal bid process?
No.
No. They are going to go through the normal rules, which is that's a purchase at the same time, and you're going to buy all 3 of them. You're going to bid them out, even though they're $40,000 each, because that's now a $120,000 purchase. Okay? And that would apply even. Cars are usually a bigger thing, and maybe you're not usually buying 3 at a time, but there's a lot of things that you're buying more, that you know how much you're going to need in a year, and you should be estimating, because you don't want to be splitting your bids, your purchases, because that can look like you're doing it to avoid going out to bid, and that is illegal to do. Now, sometimes something happens, you have an accident, and you lose, like, you're going to need 10 computers, you've got to replace them, that's going to go out for bid, let's just say computers, and you're going to buy new ones, and then halfway through the year, there is an accident and one gets destroyed. That's not splitting. You didn't intend to do that. But when you know you're going to need to buy 3 cars, you need to go out to bid on that. Don't wait until you try to buy them one at a time to avoid going out to bid on them. Okay, is there another question? Oh, I'm sorry. I don't know who it is.
Judy?
Yeah, there was
Oh,
another
it's
question
Judy,
related
sorry.
to services.
Yeah.
What are the rules on services since they are not part of the bid law?
Well, there's no rules in the public bid law for services, but it should be, you should try to shop around, basically. See who's the best quality, because a lot of times with services, you don't want to just get the cheapest attorney or the cheapest architect. And in fact, if that's getting a little bit into public works, you're not supposed to actually go for just price. You're supposed to be looking for the most qualified person. There can be several different engineers out there, and all good and smart, but for the project you're doing a water project, for example, you're going to want to maybe look at who's got experience in this type of project that you're doing. So you're not going to just go on price, and you go out for an RFP, a request for proposals, or a request for qualifications. And then you can negotiate the price per hour with them after you've got their
I would just
proposals
add
in.
to that, the Constitution's still there.
Right.
That even if it's a service, Angela used the example, the $500 hammer, you're also not going to pay a guy $100,000 to cut this little bit of grass.
Right.
That will be, the auditors will see that, and that will get you in a bad spot. So even with services, you remember the thing of the basis, public money.
Right, exactly. Your responsibility starts at $1 of spending that public money to abide by Article 7, Section 14. You're pointing to somebody, yes, yes.
Just taking that just a step further, because I am kind of not familiar with this either. I just always use professional services, like the RFPs required and the quotes are required, but I'm used to dealing with federal funds more than the state. So what I hear you saying is that it's still required because of like cost reasonableness and this other constitutional language.
Well, okay,
But the
federal,
mechanics, just a second, but the mechanics of how you get there is not spelled out in the state.
oh, okay, this lady's question is that it's still required because of the Constitution to do an RFP process, but the mechanics are not in the public bid law.
Kind of, like, whatever process you need to do to show cost reasonableness, I can't remember the term you used, but it's in the Constitution that you have to have a reasonable cost for the professional service. How you get there is up to you, as long as you can show that it's reasonable.
Well, how you get there, I would frame it more like you have the responsibility under Article 7, Section 14, to spend the public money wisely, and you want to justify that you were good and wise and prudent with it, and the way to easily show that is with an RFP process or an RFQ process. But it's not required in the public bid law to use that process for services. But you also said that something else that I'm going to bring up. You said you use federal money. The federal, if you're spending federal money, you have to follow the public bid law, and you have to follow 2 CFR 200, which is the federal procurement standards. And we advise people, if you got to do both, go with the one that's more restrictive. The federal law does require services. Now, the federal law requires services be done on a competitive process that uses an RFP or RFQ process. The Louisiana Public Bid doesn't. So if you've got federal money, you're going to have to do it that way, for sure, because they require it. The federal government goes by, they don't care what you're buying, they go by how much you're spending. They've got different thresholds based on how much you're spending, whether it's materials and supplies, services, or public works. They call it capital projects,
Right.
okay?
That's my other question.
Yeah.
So when you're talking public works in this
That's
context,
capital
that's-
projects,
Okay.
yeah.
Thanks.
Okay, oh, another question?
No, she did. Oh, was there another question out there? Back?
Now, you open all the bids, you can, for just cause, reject bids. I told you that, for example, they're spelled out in the public works side of the law, but if you budget, if every bid you get is over what you've budgeted, that is a just cause to reject the bids, all the bids even. And I would say that if that happens, you need to re-examine your estimate process of why you were so far off, and you can reject all the bids, go get more money appropriated, examine why you were so off, go get more money appropriated, and then go out to bid for that item. Yes, ma'am?
Okay, and if you do this and you get all of these bids, and like you say, it's more than you thought, what about a lease option?
A lease, you want me to-
Go ahead.
A lease option is not subject to the public bid law, not ordinarily, unless it's a lease that really is a purchase. So lease with option to buy would be subject to the public bid law. But that's an alternative if you can't afford to buy it because everybody's over that you would lease, but you really need to check the lease options and what will turn a lease into a purchase. Lease with option to buy is a purchase, okay? I think that, I just want to make sure we have that. I just want to say one thing in between. We have our FAQs, that everything that Angela is saying and Patrick's going to say, and I think I've said, you can go on our website, besides the packet we gave you, and look at all the FAQs that go into some nuances of what we're talking about, and also the list of questions that many of you have asked us that we've posted.
Yeah, I didn't tell you this when I did open meetings. You have the QR code to the open meetings FAQ on the website, and you also, the handouts, the materials that we provided has a QR code to go right to the public bid law FAQ, and the all the flow charts that I'm talking about, because we have one for the public works, we have it for the materials and supplies, and for some of the exceptions. So that's all available on the LLA's website. So, any other questions? I'll just tell you real fast before we go to Patrick's exceptions. Other just cause that can be cause for rejecting bids is for a change in the need, the public entity has changed its mind and it's not going to do this anymore or make this purchase. The failure of the bidder to align with the bid specs, again, that's more public works related. And if you disqualify all the bidders, everybody was a rotten scoundrel who submitted a bid, and you're going to have to disqualify them all, right? Now, you also have an option as a local political subdivision to adopt the state's procurement code rather than use the public bid. You can do that for one purchase, adopt the procurement code, or you could adopt the procurement code in whole. Now, the procurement code is for state executive branch agencies. To me, it's much more complicated than the public bid law, but if you do decide to adopt it in whole, you're gonna have to follow it strictly the same way you would public bid law. One thing that people like to adopt it on a case-by-case basis, and I'm gonna bring this up because it's always controversial and people always wanna do it. The public bid law does not allow for sole source purchasing. The procurement code, the state's procurement code does. But I'm just gonna tell you that sole source purchasing in this day and age is almost non-existent. Because sole source means not just there's only one person who manufactures. The public bid law requires you to go out for bid for this item or equivalent, okay? So you can put all the specs down for a John Deere tractor or equivalent if that's the kind of thing you want. But you can't say, I have to have a John Deere. But even if you could, there's more than one vendor of a John Deere. So it's not just that it's only manufactured by this one place, it's also who you can buy it from that would make it sole source or not. So it's almost non-existent. There may be some patented chemical, like for mosquito. I remember a case, a mosquito district, there's new chemical and only manufactured direct purchasing could be done. That was like a one true case of sole source in this day and age. The way things are now and we're so connected with on the online and everything, you're gonna usually be able to find multiple vendors of that product, okay? And so now I'll let Patrick take over with the exceptions to the public bid law.
Thank you, Angela. So the main thing we're going to talk about with exceptions, and the biggest exception that most people would like to use is buying off existing state contracts, because Office of State Procurement has already gone and done the competitive process to get a competitive price. And you do not have to adopt the procurement code to buy off state contract, but what we do strongly recommend is you have some formal mechanism that you document in your files that you're using that contract. It may be as simple as something in your minutes if your public entity is saying, hey, we're gonna make this purchase according to the state contract, or you do a resolution, just something so that when someone comes back and looks and goes, okay, that purchase is over 60,000, why didn't you bid it out? You have something that documents, we bought this thing on state contract, here's the state contract, here's how much it was, and here's the documentation to show what we bought is that item. Now, what the legislature has done is said, you can buy an item that's on state contract, but from a local vendor, because we want to support local business. And the most common item on state contract that entities like to buy from a local vendor are vehicles. And so we've actually added to our FAQ, and it was question 94 in the current public bid FAQ, where we worked with state procurement to go, what exactly do people need to document when they're going to use a local vendor for a vehicle? Because we get this question all the time of, well, we're buying these things on state contract. Well, what exactly is the vehicle in state contract? Because we just see base models. Does it include options, things of that sort? And so to kind of set that clear for everyone, the way Office of State Procurement interprets it, the contract that the state has is a base model item. And so whatever the base model of a Ford F-150, a Dodge Charger, whatever that is, the base model is what the state contract has. However, Office of State Procurement considers any options that the dealer presents to you, as long as those options are provided at dealer cost, to be part of the contract. So the dealer can't mark them up. it has to be the same price that they have in the dealer book, and Office of State Procurement makes it clear they have that same book, and they're going to be looking to see, is that what they actually offered you? Now, what the legislature has done to kind of help the local vendor is there is a third part of that transaction where they can add an extra percentage, 3, 5, or 7%, depending on the amounts. Most vehicles are going to be over 20, so it's going to be 3%. They're allowed to add for handling and other related charges where that's how they make their money on the purchase. So they're offering you at the base model at the same value. They're offering you any options at their dealer cost, and then they can do their 3% markup of that total amount. What that question kind of lays out for you and what state procurement expects, because as the AG had noted, that provision requires that when you complete your purchase, you have to provide a copy of all that to the Office of State Procurement, because they're going to, one, compare that what you got under the state contract, but it also gives them the mechanism if there's another potential vendor for that state contract item, especially vehicles after COVID, they have the ability to kind of maybe add them as a actual state vendor. And so what Office of State Procurement recommends, if you're going to buy a vehicle off state contract, first print the current state contract to show the base model that you're buying, because those change sometimes on a weekly basis, sometimes on a daily basis. Things will come on the contract, things will come off the contract just because of what's available out there. Then you want something on dealer letterhead, a separate document that says any options you got, here are the options, and these are all at dealer cost under what the manufacturer charges the dealer for those options. That should be your second document. So you have two things that are so far done, and then the final thing should be an invoice from the dealer saying, here's the 3%, 4%, 5%, or 7% markup that the law allows, and it should be that percentage of the other related costs. And a copy of all that needs to get sent to the Office of State Procurement once you're done. We have the contact information in that question on question 94. Amy Gotro at the Office of State Procurement is pretty much their vehicle person. It's got her email address and everything, so if you have questions when you're doing those, that should be able to help you get through those. But you can buy the same item that's on state contract from your local dealer or a local vendor, but it's got to be the same item, and it needs to make sure that other than that percent increase that they can charge, you're paying the same price that the state contract is. Now, the other, Judy, you have a question?
Yeah, I have a question. This may have something to do with state contract and also public bid. It's kind of for both things. What about those software subscription services? I know sometimes you can get those through state contract, sometimes you can't. How does the bid law work with that?
Software, if it's a true subscription, which a lot of things have gone to now where you just log into a portal, there is no software, you're not buying an actual license for stuff that's on your computer, that's a service. If you're basically just paying to log into some remote service, it's a service, an online service. If what you're getting is software that is either off the shelf or it's going to be customized by somebody, but it's still starting off with software that you download to your computer, you update on your computer, and you buy a license for that software that's on your computer, that's a material and supply. The AG has consistently said that. Which leads us into our next exception, which is when you're buying telecommunications or data equipment, things that connect to the internet or do software-related things, there is a separate provision where instead of doing public bid, you can do a 30-day RFP.
Before you go into that, I just want to make something clear that we didn't know, I didn't know. Do you get documents signed in your entity all the time? The mayor's got to sign something, the clerk's got to sign, the president of the council. We did, and we would have to move paper from desk to desk, from the first assistant legislative auditor to the auditor. Then we heard about something called DocuSign. Do any of y'all use DocuSign now? That's great, isn't it? I mean, it has like made our lives so much better. And it's all electronic, the signatures, but it's all verified. And Patrick, when we talked about it, and I asked Patrick, I said, is that DocuSign, is that on state contract? And he found it on state contract with their help, I think, under what name?
Carousel is the
Carousel.
name of the
So,
vendor.
so that was, and Angela worked with him on that. We all, we worked together. But sometimes you just need to call somebody at it's the Office of State Procurement and say, this is what I need to do. Is there anything on state contract that'll help me with that? And then we hooked on to the state's contract, so it made it a whole lot cheaper for us to get it in our office. So I just want to mention that to you, because I find the Office of State Procurement's list that's it's very confusing. And like Patrick and Angela both said, it changes. Things go on, things go off. During COVID, they had no cars on it, and so people were, all having to go everywhere for it. So I just wanted to add that before you got
Declaring emergencies
too
to do.
cute.
They were declaring emergencies too to buy, the
Yeah.
dealer would get a car, so they'd have to declare emergencies, they could go out and buy that car.
Yeah. Well, I'm sorry, you want,
This is interesting, I'm just getting a little lost in the sauce. So the DocuSign example, is that software or is that a subscription services?
it's a subscription.
So that would be considered services?
Yeah.
Can you please repeat her question, Jennifer?
Yes, I'm sorry. Is a DocuWare a subscription or a service? It's a subscription.
Okay, and then also, are you talking about piggybacking? Is that basically?
We are going to talk about that.
Okay,
We
but
will.
that's not what this is?
No.
State
No,
contract, okay.
no.
State contract is not piggybacking because you're buying,
Put your mic up a little bit.
you're buying off of the existing state contract. So, it's on. It's different than when you're trying to piggyback off another local, which are done under two different sources, which we're going to talk about. The AG under local services law has recognized you can do it from another local entity, and then this legislature put in a specific statutory method.
Okay.
The state contract is always.
State contract, it's not piggybacking.
Correct.
It's called state.
It is,
contract.
it is a state contract. You're basically, the state contracts are set up specifically so that local entities are also authorized to do it. So on the front end, they're basically open-ended. The other thing with that, I would say to Jennifer's point and Angela's point about calling Office of State Procurement, a lot of state contracts do not list items. They are a percentage off of like the catalog of whatever that vendor has. So it really, and well, some of the exceptions we're going to talk about, there is a limitation that it can't be available under state contract cheaper. You really do need to reach out to Office of State Procurement and get some kind of verification so that you don't get a gotcha because, oh, I didn't see it. Well, it may have, at the end of the day, you really don't want to pay more than you need to anyway. And so it really helps, even if that exception didn't require it there, you want to make sure you couldn't get it cheaper because that's money you could spend elsewhere. For electronics, including software, the legislature has basically put in a provision that says instead of doing a public bid process, to be more holistic. So when you're buying computers, you're buying surveillance equipment, things that use software, maybe some related services and other things, instead of trying to get something basically because they're the lowest responsive and responsive bidder, you really need a more holistic approach in picking who that person is going to be. And so what it allows for is a 30-day request for proposals process. You set up criteria. One of those criteria will probably be cost, but you may look at other things. How functionally is it? Does it work with other things? Is it expandable so that you're not having to start over again every time you need to add to that, whatever you're trying to buy? Examples of things that fall under this that you might not think of, the AG has said these smart meters that a lot of municipalities started buying so that instead of going read the meters, it can just transmit the stuff electronically because they're connected. Those fall under this. And so they're a type of thing where instead of doing a public bid process, you do an RFP process under this provision. And we, as Angela pointed out, one of the flow charts we have is specifically this process. But the key thing with the process is you need to, before you do it, come up with what that criteria is going to be, because that is how you're going to judge it. You're not going with the lowest, you're going with who scores the highest and is deemed most advantageous based on that criteria. And so it's important when you're doing something like this that you have a good team that you can trust to actually evaluate those proposals and document how you scored those proposals, because I can guarantee you, as Jenifer always says, the person who's going to want to look the most at everything that you did is the person who came in second. because they're going to know why were they not the best scored person. And in some cases, it may just be because they want to know in the future how can they do better. In some cases, it may be because they're getting ready to sue you. And so it's really important to have a process in place, make sure you have people that can follow that process, and you continue to monitor that process so that RFP is done everything by the books. Because it's an exception, you can still bid out that the purchase of all of that stuff, that computers, those meters, but this is another way to do it in a more holistic way. The other big example, exception that's out there is buying off the Federal General Services Administration. So just like the law says you can buy off existing state contracts, the legislature has said you can go buy off what the federal government's equivalent to the Office of State Procurement has done competitively and created these price lists. But in the words of Lee Corso, not so fast, my friend, there are some restrictions. The first one is it can't be available cheaper under state contract. Because if it's cheaper under state contract, you can't go use the GSA list. Makes sense, because if you can bid it cheaper, buy it cheaper. Because, I mean, as Jenifer talked about at the beginning, the whole purpose of the public bid law is because of Article 7, Section 14, that we're not donating public funds. So don't spend more money than you need to get the item. The other restriction is that item has to be purchased through a Louisiana licensed dealer or distributor. That doesn't mean they have to be located in Louisiana, they just have to be licensed to do business here. Things like vehicles and stuff like that, there is enhanced licensing you have to sell here. If anybody's worked for a school board, school buses are one of those. They have to specifically be licensed to sell in Louisiana to buy it and sell it here. And so that's going to be one of the things you need to make sure that person is not only not cheaper under state contract, but it's someone licensed to do business here that you're buying it from. So it can't be some dealer in Washington State, because that's who the federal vendor is. You need someone who's licensed to do business here. Piggybacking is everyone's favorite, because that's the one where, assuming there is no state contract, it isn't something you can do through RFP, and there is no GSA contract, the question becomes, well, we still don't want to bid it out because someone else has done it. And so historically, the AG has said local governments could look at each other's contracts that they had done under Louisiana law, under the local services law, because it allows you to cooperatively purchase things. And so what the AG set out some criteria, and the key thing under that was same thing, same or less price. So the vendor's going to give you the same thing that they just won competitively for the same or lower price than the other entity who bid it out is paying. And that contract is still viable. It's fresh. The way usually the gotcha was, if I bid out to get a fire truck, soon as I get the fire truck, the contract's over because I've gotten the fire truck. And so to be viable, it had to be like a requirements contract or a contract where you haven't taken delivery, so that it was still an active contract that you could piggyback on. Well, that didn't work for a lot of people, and so the legislature eventually created, it's in Title 38, but it's in the levy district laws, basically said local government, you can, as long as it's within a year of the bid opening, you can buy using that same contract that was previously bid out like it needed to be, and get the same thing for the same price, but not more than twice as much as was bought. You might think, well, that's odd, but it isn't. Let's say a small town is buying vehicles, and so they bid out the purchase and they get a price. Now suddenly a parish wants to buy from the same vendor and they're buying 10 times as much. Well, they're not going to pay the same amount per vehicle if they bid it out themselves. And so the built-in limitation of buying no more than twice as much is because it's practically you should have gotten probably a cheaper price if you're buying more than twice as much, because you're going to get a volume discount. And so the law for that one is a year from the bid opening, same item. You need a certification. Usually that's going to be just an email from the entity saying, we bid this out. You don't actually, the law even says you don't have to go and investigate it yourself. Just have it in your files that they bid this out, and here's when the bid opening was. You might attach the advertisement that they had, because they probably have that in their records. Then you buy it from the vendor for the same price. So you're just documenting those in your files and you're buying it. The caveat, because we talked about it earlier, if you're buying with federal money, doesn't matter if you're using the local services law or the statutory method, the feds are not going to consider that competitive because the law, similar like the public bid law, is go do the work. You need to be the one being competitive. If you're going to try to piggyback, you need to make sure you either, one, get permission from whoever granted you the money on the federal side to allow you to be non-competitive, or they may let you just kind of do some extra work to show cost efficiencies, that it would be more cost efficient and likely to get the same or maybe even more expensive price if you bid it out now because those costs have gone up. So like if you can show like fuel right now, if someone had bid out a requirements contract for fuel that had a fixed price, which is rare, it might actually be a more efficient thing to use that old contract than bid it out yourself right now, at least for the next couple weeks. And so it is one of those things. Piggybacking allows you to use other people's stuff. The most common thing that used to come out of this was, well, what about something someone did and bid out in another state? And the AG always said no, because the law, either it's local services law or statutory method, it envisions that the original contract was done under Louisiana law. However, in the last few years, we've started to get what's now called qualified group purchasing. Historically, the only entities who could do this were hospitals, because that's been around for decades. These entities that sell stuff, equipment and things to hospitals, it's a pretty regulated, heavily regulated, well-developed industry. Then schools came around and said, hey, there's a lot of entities that want to sell to education. We want to be able to buy from these qualified group purchasing organizations. The legislature expanded the law to give it to schools. And then 2 years ago, we now have one for public safety. So if you're a city or a parish who has public safety functions, it doesn't mean the whole parish can use it. It doesn't mean the whole city can use it for all its purchases. It has to be public safety related purchases. You can use what's a qualified group purchasing organization. Basically, it's an entity who does the same thing that Office of State Procurement does, General Services Administration does, or you would do yourself if you were competitively going out and trying to get best prices, and they create price lists. What the law basically says is to use these entities, they have to be qualified first, which means they either need to have two Louisiana entities, whether if it's schools, two school districts or schools that are members of that co-op, or in public safety, two Louisiana public safety entities. Or, and this was added this past year, if that entity were an entity in Louisiana, and they would be, because if they were here, they would be considered a public entity, they're gonna be considered qualified. That said, they still have to show that they actually go out and competitively create price lists by soliciting quotes from entities and creating price lists for the members to buy off of. We have a whole chart that breaks down all three of those methods. The key thing to know is if you're not hospital, school, or public safety entity, you can't use a qualified group purchasing organization. We get this question a lot. We have this Tips USA or this other company in another state that says, hey, we've already bid these out under our state law. Our state law says we can open these contracts up to other people. Well, that's great, but Louisiana doesn't let you do it. If you don't meet one of those exceptions that we talked about, you can't use their contract. That said, the AG has talked about in past opinions, the Office of State Procurement can and has adopted some of the contracts, some of these price lists off of these co-ops as state contracts. Once they're adopted, they become a state contract you can use. The best example I can give you is the contract Jenifer was just talking about, Carasoft. It was actually a contract done in the state of Utah, and it's like a massive list of software and subscription-based like services. The state adopted the multi-state contract that Utah had, and it's in effect, I think, at least for now, until September. And so there's all kind of software, Adobe, DocuSign, other, it's like a whole catalog list.
But what you want to do with all these group purchasing issues, I mean, really ask somebody. Because they got a lot of shyster types walking out there on this group purchasing. And they'll tell you, hey, everybody in Texas buys from me. Literally, I had somebody tell me that. This guy told her that. And, you know, it wasn't true. We looked it up. If they're really not group purchasing qualified, like Patrick's saying, they can get that way if they're legitimate by going to the Office of State Procurement, and they'll put them on the list, and they'll work with them. So I just wanted, because I think he's giving you a really good example, but there are people who are really trying to scam on those things.
And on those group contracts, if they sometimes have provisions that other states' law govern, which may be prohibited in Louisiana, are you still allowed to bid for that with adjustments to account for Louisiana laws?
The key thing is, if you're getting services, if part of that services, the state law says you cannot enter into an agreement with that is subject to another state's laws if those services are provided here. But the key thing there is you can negotiate those kind of venue type issues, because the key thing is you're still buying the same contract.
That thing about state law is really important in venue on the contracts that you'll get to either by total purchasing, total bidding like Angela talked about, or even the exceptions that Patrick's talking about. You want to, at that point, involve your lawyer so that you can make sure everything done under those contracts is subject to Louisiana law and subject to a venue that's close to you, like we say 19th here in Baton Rouge. But you don't want it to be subject to the law of Delaware or some other state.
So I should have told you when I was talking about bidding, when you do your contract part, your contract should be a mirror of your bid specs. So the contract should be easy. You should have these types of provisions that the lawyer has created that go in all your contracts about venue, damages, these kind of things that are like standard, but the contract for this particular winner of this bid should be a mirror of your bid specs. You want to make sure what you bid for is what you are contracting for.
The last exception we kind of mentioned is, in Louisiana, we love our festivals, we hate our natural disasters. Disaster-related emergency procurement is the last exception. So historically, there was a major difference between emergencies and extreme emergencies. The law is a little less diversified on that now, because the key thing is there's no longer a 10-day period, but the key thing is you need a declared disaster. So someone who's authorized to declare an emergency does it. If it's the city, it's the mayor. If it's the parish president, or the parish police jury president, whoever can declare it is declaring an emergency. That emergency needs to be something that's an unforeseen. And the AG is key on that. If it's something just because you didn't properly plan for it, it's not unforeseen, it's not an emergency. But the classic example is a hurricane, the roof's got a hole in it, it's raining, you can take steps to fix that. What you need to do is have a declaration that says, here's the emergency, here's what we're doing procurement-wise to address the emergency, and then you do it. And you need to document it, and you're required to keep the information for, I think it's 5 years, but we have that specifically in the FAQ. The key thing is, at some point, the emergency is no longer an emergency. If you can reasonably go out and do the 15 days to go and bid out and get a public bid done, it's really not an emergency anymore. Because we
I
have
see Judy's chafing at the bit there, and I know you are, but we'll answer your question. But if you don't, we'll answer it after, if you don't mind. We want to end on time. We want to tell you again that we hope this kind of informal way of presenting was some help to you. But you can call us. We'll talk about it on your specific situations. And we want to thank you in behalf of the legal group here, but just for the whole office, it's a pleasure to have worked with you and to continue to work.